All right, the next case set for argument this morning is State of Ohio versus Joshua Hill. It's case number 29331. Both parties are represented by counsel, so each will have 15 minutes to present their arguments to the court. Appellant may reserve up to 5 minutes for rebuttal. Just let me know if you're going to reserve time and how much, and I'll keep track of that for you. The court has read the briefs, and we are prepared to proceed if you are.
Thank you very much, Your Honor. Good morning. May it please the court, I am Alan Medlick. I'm here representing the appellant defendant in this matter, Joshua Hill. Mr. Hill had one assignment of error in this matter, and that is that the trial court erred in failing to dismiss this case for violation of his speedy trial rights. Mr. Hill pled no contest to preserve that right, and we are here today to address that matter. There are some issues that are not in dispute in this case. One is that the trial date was unquestionably after the speedy trial calculation had expired. That's undisputed by the state, either at the trial level or on appeal.
What date do you claim the speedy trial?
The exact date I don't recall. I know that the pro se motion filed on December 27th was 8 days early, so that would have been January 4th or 5th of that time on that. And the other, so the trial date of January 29th is not in dispute. The motion filed by trial counsel, Ms. Hightower, was filed after that expiration date. I don't think that is in dispute. The issues raised by the state, and I apologize, I would like to reserve 5 minutes for rebuttal.
Sure.
And the defenses raised by the state are that, first, that Ms. Hightower acquiesced in the setting of the trial date, and second, that the improper pro se motion filed by Mr. Hill would constitute a tolling of time, and the motion, and that Ms. Hightower somehow concurred in that filing according to the record. I would point out that it is the state's burden to make sure the trials are brought in a timely manner. It is not a burden placed on the state, and I think you'll find that to reach the conclusion that the trial court did, they had to reverse that burden and at every turn impute some burden onto the defendant and interpret the actions in the light most favorable to the state in this case. And we'll start first with the issue of acquiescence to the trial date. If you, when you review the record and transcripts, you'll find that there were a series of pretrials in this case. And it's unquestionable that the time at issue for the pretrials, which were continuances by the defendant's request, were attributed to the defendant. And we're past that date despite that. When we reach the pretrial of October 29th, there's discussion of setting a trial date for January 29th. And you'll find in the record that the only statement made by Ms. Hightower at that time was that that was outside of time. She says that's too late for my client. There is a discussion at that point because the trial date was set in accordance with the co-defendant's schedule. The co-defendant was arrested later. These are discussions that are had in the transcript of the 29th of October pretrial. And the matter is set up for 2 weeks to allow the sides to investigate that further. And on the pretrial on November 14th, on the record, there is no further discussion from either the state or Ms. Hightower or the court for that matter. The trial date is simply affirmed, and in the record, the trial date is affirmed as January 29th. At that point, there was no explanation from either the court or the state as to why that date would not be outside time. Ms. Hightower had already put the court on notice at the end of October that that date was outside of time. So to interpret that there was some sort of acquiescence by Mr. Hill and his trial counsel in that matter, I think is at best a stretch. And so there was no acquiescence on the part of the
Did she agree to that trial date
She,
on the record?
there is nothing agreeing to that trial date on the record. That is simply, and when you read on the 29th, on the November 14th, I think you will simply find the trial judge state you have a trial date of January 29th, and you have a trial date of final pretrial January 14th. I think is the date, or January 20th. Yes, January 14th. There is no discussion about that. The journal entry, and when a defendant's attorney is silent regarding the a trial date outside the speedy trial, it's not a waiver on the part of the defendant. That's not what is considered when you look at the case law. The McRae case cited by the defendant, or by the state rather, will state that what it is a continuance by motion other than by the defendant under section 2945.72H, and in that case, that can be considered a reasonable extension if it is explained in the journal entry. What those reasons for that extension are, you look at the journal entry setting the trial date. It is silent regarding any reason to set this beyond the trial date. There is no indication that there was acquiescence or an appropriate consideration for that continuance beyond the trial date in the record. So, regarding the issue of waiver on the part of Mr. Hill, that is unsupported by the record. The second issue is that Mr. Hill was unquestionably represented by counsel throughout this entire process. In December, on December 27th, 2018, 8 days prior to the expiration of the speedy trial deadline, Mr. Hill files a pro se motion styled as a motion to dismiss for not being brought in time. And at that point, Mr. Hill was represented by counsel. The law is clear that dual representation is not appropriate, and that pro se filing is a nullity. That's undisputed in the record, or in the law. Ms. Hightower's response to that motion was to both orally and in writing file a motion to strike that pro se motion as a nullity. And then subsequently to file, after the expiration of the trial date, of the speedy trial date, a motion on her own behalf, on her client's behalf, after the expiration of that date, which would be timely. The state has gone through some gymnastics to try to assert that Mr. Hill's pro se motion was adopted by Ms. Hightower when she filed her subsequent and timely motion for dismissal. I still am having trouble articulating the argument because I find it to be disingenuous and difficult to understand how the filing of a motion to strike an improper motion is at the same time adopting that motion. Ms. Hightower absolutely understood that there was a speedy trial issue in this case, and that she intended to raise that issue if and when it came up and was timely. That her client, on his own and improperly and without authority under law, filed a motion which under law is a nullity, and would be untimely, but somehow her intent somehow imputes her adoption of that motion is I have trouble finding a way to argue that.
Counsel, let's say it's not an adoption, and let's say that a pro se individual who files a pleading while represented by counsel, that is a nullity because you can't have dual representation. Nonetheless, for speedy trial purposes, the court had before it a pro se motion and then a motion to strike. So you don't think that warrants any type of tolling whatsoever?
The motion to strike was filed after the date would have, and I don't, and as I argue in the reply brief, I think that what you're talking about here is it is, because it is a nullity, because it is stricken, the pro se motion and the court, the prosecutor and Ms. Hightower all understood that this was, that Mr. Hill's pro se motion was useless paper, for lack of a better word. Any reasonable extension of time was to pursue that, that pro se motion. That the only reasonable response is that there was none. Everyone there, the law is clear that it's a nullity, and this was a motion to strike, which removes that from the record. The pro se motion is considered to have not been there. That is the distinction between overruling a motion and striking it.
We're at 4:40 right now, counsel. Do you have?
No, that's fine.
And I'll say the balance. That is my response, is that the,
Well, now you're.
I'm sorry, I'll stop talking.
You're gonna save it, save it.
I'll say it.
All right, you're left 4 minutes and 40 seconds.
Thank you.
Very well. Counsel, you'll have 15 minutes on this one.
May it please the court, Kevin DiMartino, guest on behalf of the state of Ohio, the appellee in this matter. We are asking that this court affirm the trial court's decision with regard to the ruling on the speedy trial issue. This state would begin by arguing that trial counsel did in fact extend the speedy trial deadline by agreeing to the trial date. The record shows that at the October 29th hearing, a trial date was set to go along with the co-defendant. At that time, trial counsel said, I think that's going to be too long for him, but then did not disagree when the court set the date. Also, counsel did not say at that time, and that's on page 3 of the transcript, counsel did not say that's too long because it's outside a speedy trial. There was no argument made about whether that is outside.
I mean, yeah, your counsel too. Counsel, why is that the trial counsel's duty?
If they're going to raise that argument, I'm saying that she agreed to it based on the fact that a trial date was given. She didn't raise the speedy trial argument. She didn't disagree with the date, that therefore she agreed. He's arguing that because all she said was, I think that's going to be too long, that was her disagreement with the trial date.
I understand what the arguments are. I guess I'm just trying, it seems like to me though, you're, like putting a little bit of burden on, not a little bit, a lot of burden on the defense counsel and saying, well, if you don't step up and say, that's out of time, and you just sit there silently, then you've acquiesced to it.
I think if you take the trial date without saying we would like a different trial date, I think you are agreeing to the trial date. So I'm not offering that statement of hers to say that she has a burden to say that's outside the speedy trial time. But I do think if you're going to say you didn't agree to that date, and case law says if you do agree to that date, then you have extended the trial time. I don't think you can then come back now with nothing in the record and say, well, when I said it's too long, what I was actually saying is I don't agree to that trial
What
date.
if she said nothing?
If she had said nothing at all, I would make the same argument, especially because she came back on November 14th and she asked for a trial date, and the court said, noting that we were already set for a final pretrial January 14th and a trial date of January 29th, I'll give you some time to file some motions. And then defense counsel said, quote, okay, thank you, Your Honor. And that's on page, I believe, 3 of the November 14th. So there's two separate statements where there's a trial date given and counsel does not disagree to it. And then the journal entry comes out on November 20th and there's no objection, no disagreement with the trial date at that time. So if after that October hearing or after that November hearing, or certainly after the journal entry came out in November, if trial counsel had said, we filed some type of objection saying, I never agreed to this date and it's outside a speedy trial, then I think counsel could come in and make an argument to this court that trial counsel did not in fact agree to the date, but this record shows that she did agree to that date.
The reason I'm having a little bit of problem with this, I'm trying to understand, because it sounds to me, again, like the state is shifting the burden from itself to the defense and saying, you have the obligation to raise it to the court that this is outside the speedy trial.
Well, I think I'm saying that she has an obligation, if she disagrees with the trial date for whatever reason, then she has an obligation to say, I don't agree with the date.
But then she's, if she says, I don't agree with the trial date because it's outside the speedy trial time limit, then she's basically put in a hard position because she's representing her client, and she's not representing the state of Ohio.
Right.
The state of Ohio has a burden to bring a defendant to trial within the speedy trial limits.
Right, well,
And if she she in essence then basically done a disservice to her client, not representing the interest of her client,
I
which she should.
I think when there's a co-defendant and you're agreeing to a trial date to go along with the co-defendant, and with case law from the Ohio Supreme Court in State versus McRae that says if you agree to a trial date, you can extend speedy trial. I think that there are a lot of reasons why trial counsel would agree to extend a trial date outside of speedy trial, especially when you have an inmate, so you're only looking at 90 days. So I don't think it's per se disservice at all to agree to a trial date outside of the speedy trial time, when in all likelihood you're going to be outside of that time frame anyway. And there's nothing in this record to show that it would have been a disservice to him as far as getting, things ready. There was still talking about discovery at that time in October, November. There was still discussion about there might be more discovery that needed to be done. Defense counsel was indicating at both of those hearings that she was still likely to file a motion to suppress. So there's nothing in the record to show that by agreeing to a trial date outside of speedy trial that it was in any way ineffective assistance or not doing, a service to a client.
Counsel, it's been a long time since I was on the trial bench, but I can remember sitting down with attorneys and saying, ready to get their calendar out,
Mhm.
and trying to come up with an agreeable date. I see that as different than just the judge picking a date
Mhm.
and the attorney just not objecting. What's your response to that?
Well, I think that when that does happen, and there's a date picked, I think that at that time you have to either raise it or raise it immediately after when it's journalized. And in this case, like I said, there were 2 separate hearings where the date was discussed, and then there was a journal entry that came out. And at any of those times, the defense attorney could have raised that argument or said, for the record, I disagree with the court's journal entry of the trial court date. I never agreed to that date, and in fact, I'm asking for a date that is earlier. There's certainly procedural mechanisms that could have taken place within the trial court if counsel did not agree to that date. So at this time, my argument is that she agreed. It sounds like their argument is that there's nothing in the record to show that she did agree. So I'm offering those items to show that she actually was in agreement. So I think that the argument that was raised and the way the issue is framed before this court is a little bit different perhaps than the way it was argued today. But my argument would first be that agreeing to a trial date extends speedy trial under State versus McRae. In this case, the record supports that trial counsel did agree to that trial date that was outside of speedy trial time. And even if trial counsel had not agreed to that date, that the motion that was filed by the pro se defendant would have extended time. So I understand that the arguments that were made are a little, atypical maybe in this case. It was a pro se motion that was then there was a motion to strike made by the defense attorney who raised basically the same arguments. The argument that was raised by the prosecutor below was, twofold basically. One, that by adopting, or at least the logic and the argument raised by the pro se defendant, that defense counsel was, for lack of a better word, joining in, and therefore that date would be the date that we would use for tolling for speedy trial under 2945-72H. My argument today is that the case law that talks about whether a pro se motion is a nullity because there's no hybrid representation doesn't say that anything filed by a pro se defendant is a per se nullity. In fact, the case law talks about that it can be adopted by counsel, and then in that case it is not a nullity because it would be adopted. So to say just carte blanche or a nullity and everyone should have known to ignore it, that isn't correct. And the court didn't rule that way in the trial court, and I don't see any case cited by the defense that says that if there is a motion filed by a pro se defendant, one, it's a per se nullity and the court can just ignore it because there could be some merits to a motion that was filed. And two, even if it was a nullity, that doesn't impact 2945-72H. That says that time is told by motions filed by the defendant. And I believe that the court has a duty to review these motions just in case there is some merit to it, and that the state should not be held to presume that the statute, as it's written, the plain language of the statute, doesn't apply if there's a pro se motion that's filed because of the prohibitions against hybrid representation. And the state would argue that in this case, the court really doesn't need to get to that second issue because the trial counsel in this case did in fact adopt the trial date, which thereby extended speedy trial time, and therefore the court would not have to get to this issue regarding the pro se motion and the impact that it may or may not have on 2945-72H.
So under your argument, if he would have filed a pro se motion on January 5th or whatever the trial deadline after it expired, the court should have considered that and dismissed the case?
I think the court should have considered the merits of it, and that it should have, in fact, in accordance with the plain language of the statute, told time, so that the court could at least look at it and see if there was merit to it. I don't believe that there is
Meaning
clear.
that if it was filed after the trial, the trial deadline expired, so the problem here is he filed it too early, you're saying? His pro se motion.
His pro se motion was filed within the speedy trial deadline and pursuant to 294572H by filing that at told time. And I don't think that the legislature's intent was for anyone to look at a motion, individually decide the merits of it, especially as, you know, another party in the case, as the state, to say, well, I'm going to say that that is a per se nullity, or for the judge to say, well, that's a per se nullity, so it doesn't count, I'll strike it, and then speedy trial is not told. None of that happened in this case, so the state wasn't on notice that this was going to be something that would not told time pursuant to the statute. The court did not find that it was a nullity that was struck from the record and thereby did not told time. So for appellate counsel to come in and say, well, it's a nullity, everybody knows it's a nullity, therefore that's what happened, it's not what happened. And the case law is not that clear. And there is no case law that talks about if it's a pro se motion, where there is also a defense attorney, that is a nullity, and because it's a nullity, it now affects speedy trial time under 294572H. There's no exception in the statute for pro se motions that are filed. There's no exception in the speedy trial statute that says, well, unless that motion that was filed was a nullity, it has been declared a nullity so that all parties know that time is told. So based on that, the state would ask that this court affirm the decision of the trial court.
Can we go back to the October 29th retrial? Counsel indicated that the court rescheduled that particular pretrial to November 14th, I believe, specifically to discuss or to have the parties research the speedy trial issue.
That's correct. And at that point,
Is that an indication, though, that the issue was raised?
well, they raised, I have to go back, they were talking about raising other issues, including, I have it right here, I can look at it, but what they were raising was other issues too, any other,
But I thought your argument was that the defense counsel did not raise the speedy trial issue by saying it's too long for him. If that were the case, it seems to be in conflict with the court saying, let's research the speedy trial issue.
the issues that they raised were, let's see, I don't believe that it was speedy trial that was set, so let me just go back and check. It says, I received this, on page 2, I received discovery from the state, I haven't had an opportunity to review it with Mr. Hill, there may be some constitutional rights violation. I think at this time we're prepared to request a final pretrial and a trial date. I would ask the court for relief until next week, in case I did have the need to file a suppression. And then they talk about possibly a severance. Then they set the trial date. She's asking for a little bit more time. And then any time to review the matter for any concerns that you might have as far as reviewing whether or not to set the trial with the co-defendants. So there's no mention of speedy trial that I see. It's only 5 pages long.
All right, thank you. Any other questions?
Any other questions I have on the brief? Thank
All
you.
right, thank you. Counsel, you'll have 4 minutes and 40 seconds for your rebuttal.
Thank you. I think the transcript is clear from that October 29th hearing, and as was just attested to by the state attorney. The discussions of suppression and other potential issues, she was not seeking another pretrial date at that time. That was prior to the discussion and the discussion of the trial date. When she was discussing suppression, she wanted to try to set the trial date and then have a week for leave to file a potential suppression motion. That's what's stated in the record. I'll leave that to your review. Regarding the issues of agreement by the prosecutor or standing silent by the defense attorney, standing silent versus waiver, the law is clear that the trial attorney cannot waive his own the client's speedy trial right. That has to be done by the client on the record and in writing, with knowingly, voluntarily, and intelligently. There's no question that was not the case here. The only argument here is whether the continuance under 2945.72H is appropriate as a reasonable continuance by the court itself. The state has referred to State v. McRae a couple of times. I would point you to State v. King, 70 Ohio State 3rd, 158, which states that which interprets and limits King, distinguishes, because an extension beyond time must be reasonable, and the reasons for the extension beyond time must be stated in the journal entry. There is nothing in the journal entry or in the record to indicate why this was a reasonable extension. And I would contend that the context of the transcript from the 29th is clear, that the discussion of that being too long is unquestionably about the speedy trial right. And it relates to the date of arrest by the client, the fact that Mr. Hill had been detained in the facility the entire time, so that there's a limit to 90 days on the window for bringing trial, as opposed to the usual 270 for someone who's out.
He never asked for a separate trial from his co-defendant.
It was discussed. It was then this continuance to the 14th was there, and the trial court set the date. There was no further discussion beyond that on the 14th. I would agree with the state on that, but I think that the court and the prosecutor were both on notice to discuss why this was appropriate, and neither of them did. I'm not sure that she needed to bring that back up as high time. To the issues of the nullity concern, the state wants it both ways. That if Mr. Hill filed that motion timely, it would be unquestionable that it would be stricken as a nullity. That would be a consideration. There's no distinguishing. I mean, a nullity is a nullity. You don't consider it as part of your law. So we had filed it and had it be, it's a non-entity. It's a void ab initio. It does not exist. To claim that this is something that the legislature intended to be considered when hybrid representation is clearly improper is a stretch. It's unsupportable. And Ms. Hightower in no way intended to adopt it, and that's why she filed a motion to strike this.
Does the court have discretion to consider a pro se defendant's
I would say they do not. No. The issues, and the state both here and points to a case, State versus Castagnola, where there was a clear adoption of the issues raised in the pro se motion by the defense counsel. There were arguments raised in support of that motion. The motion was considered, but only when it became clear that this was not a hybrid representation and that the defense counsel was in fact arguing these same points. The purpose here, and Ms. Hightower's efforts have always been to distinguish that this was an untimely motion, and that she understood that the trial date was, that she understood what this law was. I think that's what's clear from this record, is that she understood when the speedy trial date and the speedy trial deadline were, and Mr. Hill, for whatever reason, filed this motion and untimely, without consulting or without discussing with counsel. That's why we have
time. Counsel, you're out of time.
Thank you very much for your time.
Thank you for your arguments, both of you today. We'll take the matter under advisement, issue a decision in due course, and the clerk of courts will certainly mail each of you a copy of the court's decision on the day it's released. You can also find the court's decision on the Supreme Court of Ohio's website, where our opinions are posted. Thank you again for your arguments this morning.
Thank you.